It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. Now that I got your attention, I guess I should probably mention I got a new album available now on my site. Nigga, fuck all that whining and bitching. You looking for greatness, then I'm the description. Dropping me by like a prison. Twisting your brow like ignition and split, nigga. That's what I call on the vision. I'm finna infiltrate, you cannot imitate. I'm from a pedigree, this is not Triple H. I took a road, you can't travel like Triple A. Do the impossible, just like a triple play. Genuine energy, I am not Timberlake. But a nigga too insane. Truck for the money, better pull up in the ring. So I can give a what the fuck about what a nigga think. I'm on some new shit. Elevator my rubric. I'm an industry nuisance, giving my 2 cents. Telling niggas what the truth is. It ain't even about music. Everybody wanna know the cheat code. Bitch, I got bops on reload. I was just on live 2 hours straight. Ain't playing not one repeat song. I'm ready for the spotlight. I was on the block like a stoplight. Every day I catch lightning in the bottle. These niggas told lies, but not hitting spots twice. Couple years I was living on fried rice. Like a tree when I got to eat Popeyes. Gotta beat them and get your whole top 5. Spit heat on top like a rabbi. It's Nolan. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there this evening. Got a big news update for y'all concerning the Megan Thee Stallion Milagro Gramz legal saga. Okay? As y'all know, there was a multi-year campaign going against Megan Thee Stallion from Tory Lanez. The DJ That Don't Spin was in on it. Milagro Gramz was in on it. Aiden Ross was in on it. The DJ That Don't Spin and Aiden had to answer for it in form of depositions, which they didn't like very much. And then, of course, we have Milagro, right? She lost her trial against Megan Thee Stallion earlier in this year. Unfortunately, at the time, there was a bit of a discrepancy about whether or not Milagro should be deemed as a media defendant. At the time, the jury said no. They said yes. The jury said yes, right? Being that she has an online show, she does videos disseminating news or current events, trending topics, etc. So they basically put her in the same category as all of the rest of the YouTubers, the rest of the online shows, journalists, etc., etc. And because they found her to be a media defendant, they basically told Megan Thee Stallion that she should have given Milagro a cease and desist letter, or at least an opportunity to delete the offensive, perhaps defaming posts, videos, content, deep fake sex tape, etc., before hitting her with a lawsuit. Right? So initially, Milagro was hit with a $75,000 fine, but because they saw her as a media defendant, they knocked it down to $59,000. In the time after that, Megan Thee Stallion has pleaded to the courts that she is not satisfied with that. She believes that Milagro was indeed not a media defendant and pushed back on that and wanted her initial judgment reinstated. As of today, the judge has done just that. Proposed, ordered, and so adjudged. Milagro Gramz is no longer deemed a media defendant and shall be held liable for the $75,000 on her defamation case. I have the paperwork. Remember, initially when the judgment was put in, Milagro said this was a win for new media. She did an interview with Armand Wiggins. Both of them said this was a win for new media. Tasha K congratulated her as a win for new media. Just a few months later, new media takes an L. Okay? Let's get to it. All right. So this is the order coming from the judge. This cause came before the court on plaintiff Megan Pete's motion to reinstate jury verdict as to defamation claim and to amend final judgment or renewed motion for judgment as a matter of law. Defendant Milagro Elizabeth Cooper filed a response to which plaintiff filed a reply. The court has reviewed the parties' written submissions, the record, and applicable law for the following reasons. The motion is granted in part. Background. On October 24th, 2024, plaintiff, professionally known as Megan Thee Stallion, filed suit against defendant, an online personality known as Milagro Gramz or Mob's World. Plaintiff alleged that defendant coordinated a social media smear campaign against her following the 2022 conviction of Canadian rapper and singer Daystar Peterson, known professionally as Tory Lanez, aka Mr. They're harassing me in prison, and the judge said, "Fuck out of my face," on charges related to a July 2020 incident where he shot plaintiff. Plaintiff asserted that defendant acted as Peterson's longtime mouthpiece using multiple social media platforms, including Instagram, TikTok, X.com, and YouTube, to spread vicious and hateful rumors to her more than 100,000 followers in retaliation for plaintiff's testimony at Peterson's trial. On December 10th, plaintiff filed her amended complaint asserting 4 claims for relief. Defamation per se, count 1. Promotion of an altered sexual depiction in violation of Section 836.13 Florida statute, count 2. Intentional infliction of emotional distress, count 3. And cyber stalking in violation of Section 784.0485 Florida statute, count 4. In a motion to dismiss the amended complaint, defendant argued plaintiff's defamation per se claim should be dismissed because plaintiff failed to comply with a Florida pre-suit notice requirement. Under Florida Statute 770.01, at least 5 days before a plaintiff sues a news media defendant for publication or broadcast in a newspaper, periodical, or other medium of a libel or slander, she must give written notice to the author specifying the article or broadcast and the statements therein which he or she alleges to be false and defamatory. Plaintiff insisted the statute did not apply because nothing in the amended complaint was sufficient to support a finding on a motion to dismiss that defendant was a media defendant entitled to such notice. Accepting the amended complaint's allegations, the court found defendant was not a media defendant. That was the judge's original judgment. Plaintiff then filed a second amended complaint to which defendant responded, reasserting the defense of lack of statutory pre-suit notice. No summary judgment motions were filed during a ruling on the affirmative defense. As trial approached, the parties came before the court for a series of pretrial conferences. At a November 10, 2025 pretrial conference, the parties and the court discussed whether the jury should decide the matter of defendant's media defendant status. Defendant's counsel argued in this case whether defendant is a media defendant should be a question for the jury. The court then suggested the parties preface the relevant jury instructions with the phrase, "as to media defendants," prompting the following discussion. Defendant's counsel: I don't have an issue with that, plaintiff's counsel. So yes, they would have to find the factual predicate that she's, and then we have to give them some guidance. I would say the motion to dismiss. The court: what is a media defendant? What does that mean, right? Plaintiff's counsel: right. Plaintiff is, of course, Megan Thee Stallion and her counsel. And I think if you look at it, it has some standards, but I don't know if that is a jury issue. But yes, you could set it up that way, and I guess we will be okay with that. The court: I think plaintiff, it's fair. Following the discussion, the parties agreed to work together to draft a jury instruction based on the court's suggestion. But the issue remained unsettled as the case advanced to trial. On November 12, 2025, plaintiff filed a memorandum reasserting that defendant was not a media defendant. On the first day of trial, the court stated it agreed with plaintiff, but noted if the defense wants to present something to the contrary to persuade me otherwise, certainly may do so. On the 5th day of trial, the parties agreed that jury instructions would reflect the court's ruling unless defendant's briefing persuaded the court otherwise. The next day, defendant submitted a response memorandum, and plaintiff filed a reply. Defendant then asked the court to defer ruling on defendant's media defendant status until after the close of the evidence. Later, defendant moved for judgment as a matter of law under Federal Rule of Civil Procedure 50A, which the court denied. Evidence concerning defendant's media status. At trial, defendant presented evidence regarding her business operations, trademarks, and media activities starting in 2017. As defendant testified, she formed her limited liability company on May 23, 2020, and discussed her trademark moniker, Milagro Gramz, under which she provides entertainment in the nature of live performances distributed via various platforms across multiple forms of transmission media by an entertainer in the nature of ongoing live radio personality performances, entertainment in the nature of visual and audio performances by an entertainer, namely live visual and audio performances by a radio personality host. Entertainment, namely live commentary in the nature of providing information, news, and commentary in the field of entertainment. Entertainment, namely personal appearances by an entertainer in the nature of a radio personality host. Entertainment services, namely providing a website featuring entertainment news and entertainment commentary information. Milagro Gramz trademark. On May 22nd, 2020, defendant filed a certificate of formation for Mob Radio LLC, under which much of the same. Defendant testified that since 2017, she has used social media and other online platforms such as Station Head, YouTube, Twitch, Kick, Instagram, and Twitter to report news, hold interviews, and blog. Defendant was featured by Station Head on October 8, 2019, and approached by the Shade Room on December 11, 2019, about joining its podcast network on Spotify. She has collaborated with groups like the Shade Room and On Site and contracted with Station Head after completing a one-year trial period. Defendant testified that she obtained these opportunities either before or independently from her relationships with Daystar Peterson and his father, Sunstar Peterson. She described a broadcasting schedule spanning several hours a day, covering topics from politics and world news to entertainment, and she testified that she reported on events including Peterson's trial as a member of the media. Plan Exhibit J336, a July 30th, 2024 episode of Defendant's Show that discussed 7 topics spanning over 1 hour and 36 minutes before plaintiff's name was mentioned. 3 claimed defamatory statements. Plaintiff accused defendant of acting as Daystar Peterson's longtime mouthpiece when uttering 3 defamatory statements. 1. Defendant's statement that plaintiff was a non-credible witness. 2. Defendant's statement that she could go down the list of all the different shit that was not true. And 3. Defendant's question, was Megan Thee Stallion caught trying to deceive the courts again? The jury found by a preponderance of the evidence that defendant was liable to plaintiff for defamation per se based on those 3 statements. The following summarizes the trial evidence concerning the 3 defamatory statements and defendant's communications with Daystar Peterson and his father, Sunstar Peterson. On July 12, 2020, the Los Angeles Police Department stopped Daystar Peterson's vehicle after receiving reports of shots being fired, arresting him on charges of carrying a concealed weapon. 3 days later, plaintiff announced on social media that the injuries she suffered the night of Daystar Peterson's arrest were gunshot wounds, and on August 20, 2020, plaintiff publicly identified Daystar as the shooter. On September 17, 2020, Daystar Peterson sent defendant an Instagram direct message requesting her phone number. Defendant responded by providing her number and stating, "I don't know how you're doing your live tonight, but if you gave me that or any exclusive, it changed my life." Around September 24th, 2020, Sunstar Peterson sent defendant an Instagram message stating, "Hello, Mila, this is Tori's dad. Been listening to Mob Radio. I would like to talk to you off the record." Just days later, defendant interviewed Sunstar Peterson around September 28, 2020. Defendant's relationship with the Petersons continued after the interview. Sunstar Peterson and defendant often communicated by phone and text. Text messages between defendant and Sunstar Peterson between September 25th, 2020 through December 23rd, 2024 Sunstar made 5 payments totaling $2,500 to defendant between October 2020 and April 21st, 2021. $500 on October 28th, $1,000 on February 23rd, 2021, $300 on February 27th, 2021, $200 on March 7th, 2021, $500 on April 21st, 2021. Further, defendant openly discussed her close relationship with the Peterson family. For example, in a June 18th, 2021 text message, Emil Holland Briggs stated, "Who else can say they have this kind of relationship with Sunstar and Daystar?" Great question. Defendant testified that as a thank you for being unbiased, Daystar Peterson's team provided information to her before sending it to TMZ. Sent her the information before TMZ, you say? Defendant also supplied Sunstar Peterson with information. For example, on November 24th, 2022, Sunstar texted defendant, "Mila, can you please send me those materials ASAP? This is go time now, and the attorneys need them as quickly as we can get them." The next day, defendant emailed things that may be of value, including screenshots of social media posts by plaintiff's former friend's mother and sister criticizing plaintiff, information from a conversation with plaintiff's former friend, screenshots of a post from plaintiff's ex-boyfriend implying plaintiff physically assaulted him, and a video showing defendant discussing those posts. And on December 2nd, 2022, defendant sent Sunstar at his request a video of plaintiff in a pool with a gun. So as you can see, Tori's dad hit up Milagro, said, "Please send these materials over ASAP." And all of the materials were negative things about Megan in particular. "It's go time," he said. Daystar Peterson's criminal trial began on December 12, 2022. The next day, Daystar sent defendant an Instagram direct message asking, "What's your number? Gotta ask you something." And defendant provided her number. On December 21st, 2022, Daystar texted defendant, "It's Tori, hit me." That same day, defendant uttered the first defamatory statement, a post on X from her Milagro Gramz account calling plaintiff a non-credible witness. On December 23rd, 2022, the jury entered a guilty verdict against Daystar Peterson. Sunstar and defendant remained in contact following the verdict. Text from December 27th and 28th asking defendant to call him. On January 5th, 2023, Sunstar texted defendant, "Hi Mila, call me ASAP." That day, defendant appeared on DJ That Don't Spin's podcast to discuss the Daystar Peterson trial and made the second defamatory statement. "I could go down the list of all the different shit that was not true that I've been saying. That's not true. That's not true." On January 12, 2023, Sunstar asked defendant to call him because Instagram had wiped his page and instructed her to please let the people know. Let the people know what? That your page got deleted? What the fuck did you do? Months later, on June 10th, 2023, Sunstar invited defendant to a Zoom meeting entitled Friends of Sunstar and Daystar. During the meeting, a user identified as Tory Lane's source stated it was important to emphasize that Tory has never made it his mission to weaponize his fans against plaintiff despite what the DA claimed. The user further stated, "With this news, it's better to have other people saying that instead of Tory," and emphasized it has to be a third party, not from him. Things he say can be held against him putting this out. I don't remember seeing this information. Not the Zoom meeting where you got Tory Lane's source, whoever the fuck that is, saying, "Hey, the things that Tory wants out there, it has to come from someone else, not him. Things that he says could be held against him. We gotta do it." I didn't know about this piece. Defendant then shared a transcript highlighting a sentence implying plaintiff stepped on the glass. the night of the shooting, and asked, are things like this along the lines of what you're looking for? Boom! Headshot. Defendant being Milagro Gramz, by the way, people. So homeboy says, hey, we need other people putting this information out there. It can't come from Tory. He can't say shit. It gotta come from outside parties. Milagro jumps in with the step on glass thing. Is this what you're looking for? A day later, Sunstar and defendant exchanged messages regarding a failed Zelle payment and agreed to switch to Cash App. A day later, defendant's post about plaintiff continued. This is all from the judge, by the way. An outline of events. Defendant's post about plaintiff continue. Ooh, I can't stand her motherfucking ass. Just shut the fuck up. That is a quote. On February 28, 2024, Sunstar asked defendant whether she would be willing to speak with a producer involved in another high-profile lawsuit because he can't speak at this time to anything that links Daystar's case. Defendant agreed to speak with the producer. In the ensuing months, defendant's post about plaintiff intensified. On June 8, 2024, defendant posted on X, go to my likes. This is the deepfake. Directing users to a deepfake pornographic video of plaintiff. During a July 30th, 2024 live stream, defendant asked if plaintiff had ever been deemed like legally y'all know. Stated, you better get that bitch away from me before I run that hoe over with this motherfucking car. And reiterated her belief that the damn girl stepped on glass or a ricochet shit came and fucked up. Now help me understand this, people. This woman literally acknowledged the possibility of a ricochet. What ricocheted? Was it rubber? Was it a Wendy's cup? Was it a pair of jacks? Dice? No. In order for there to be a fucking ricochet, it would have to have been a shot fired. I'll digress and continue. On August 1st, 2024, defendant again discussed plaintiff during another live stream, stating, what does losing somebody have to do with lying on some damn body? So if you lost somebody, it's okay to lie on people and get them sent to prison and make money out for the propaganda in the bullshit. Less than a week later, defendant issued the third defamatory statement on X from her Mob's World account accompanied by screenshots of legal documents from another case asking, was Megan Thee Stallion caught trying to deceive the courts again? The jury's dumbass finds defendant was entitled to pre-suit notice. As the end of trial approached, the court gave the parties the option to wait until the evidence is closed for a ruling on defendant's media defendant status or to address the issue then. Plaintiff's counsel asked if the court viewed defendant's media status as a question of law, to which the court noted that while media status is typically resolved at the inception of the case, here the issue was resolved at the motion to dismiss on the record that the defendant presented and based on the pleading alone, but the record is materially different from that which the court was presented at the inception of the case. The court had directed the parties to confer on how to proceed, including whether to submit the question of defendant's media status to the jury through a special interrogatory. Following conferral, plaintiff's counsel requested the issue be submitted to the jury while defendant insisted on the court announcing a ruling as matter of law. I'll hear from the parties. Plaintiff's counsel, yes, Your Honor. So we have conferred and thought about this. Our side is okay with the issue as we talked at the first pretrial conference going to the jury. If we can get reliable criterion for which they would decide it, which should be the same criterion you used at the beginning of the case and you would have used on summary judgment, and we raised that with the other side, but they are not okay with that. They want you to rule yourself on the record. After the court gave assurances that post-verdict briefing on the issue would remain available, defendant withdrew her request and both parties agreed to proceed with a special agreed-upon interrogatory. Plaintiff's counsel further explained he was just concerned about the record not being complete, but now that we have merged these things, I think it's fine. The next day at the lunch break, plaintiff sought to make an oral motion that defendant had failed to establish she was a media defendant. As the court advised, plaintiff could reserve on the motion. At the close of the evidence, defendant moved for a directed verdict on plaintiff's IIED claim, which the court denied. Defendant's motion for directed verdict. The verdict form contains 6 questions related to defendant's news media status. Question 3. During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper provided disinterested and neutral commentary rather than advocacy for a particular client or personal interest? Question 4. During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper regularly disseminated news or information to the public rather than an isolated or one-time publication? Question 5. During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper impartially disseminated information rather than acting primarily to promote her own business, products, or services? Question 6. During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper operated for the purpose of informing the public about matters of public concern through news reporting, analysis, or commentary? During the time period when the statements were made, do you find by a preponderance of the evidence that Ms. Cooper functioned in a similar manner to traditional news media such as newspaper, magazines, television, radio, or their online equivalents? Question 8. Considering your answers to question 3 through 7 together, do you find by a preponderance of the evidence that Ms. Cooper should be treated as a media defendant with regard to the statements made in this case? During deliberations, the jury submitted a question regarding the media defendant issue, asking, if we believe half, is that considered a yes? The parties agreed that the court should respond, there is no set number. Plaintiff's counsel proposed the following answer. So our proposal, if you were inclined to say something, is to say that though there is no set number of factors that conclusively determine the outcome of the question on media defendant, the courts in this circuit have indicated that the answer to question 3, whether the defendant is disinterested and neutral, are the most important in the analysis, and that a defendant should not be treated as a media defendant if the answer to question 3 is no. That's our proposal. I mean, we have something that we attempted to be more practical, and the proposal there, although your answers to question 3 through 7 should guide your answer to question 8, the media defendant question, the considerations referenced in questions 3 through 7 are not exhaustive, not dispositive, and not necessarily entitled to equal weight in answering question 8. You are free to give those considerations whatever weight you think each deserves in determining the answer to question 8. Thus, answering yes to a majority of questions 3 through 7 does not mean that you must answer yes to question 8. Likewise, answering no to a majority of questions 3 through 7 does not mean that you must answer no to question 8. Ultimately, you should consider all the factors together to determine if the defendant should be considered a media defendant. The jury found for plaintiff on counts 1, defamation, 2, promotion of altered sexual depiction, and 3, IIED of the second amended complaint. Although its answers to the news media interrogatories were mixed, the jury concluded, considering the effect of the answers, that defendant qualified as a media defendant. After the jury was dismissed, the court discussed preparation of the final judgment. So they did find her liable for defamation, promotion of altered sexual depiction, and 3, intentional infliction of emotional distress. But then they said she's a media defendant, which contradicted the defamation to begin with, which then goes into the media defendant requirements, right? Plaintiff's counsel expressed the weight of the evidence is that defendant is not a media defendant, but understood that's the way the jury filled out the verdict form, noting his objection. Given the jury's findings and plaintiff's failure to give pre-suit notice, the court entered final judgment on counts 2 and 3 in plaintiff's favor, but not as to count 1. The present motion. Plaintiff now asks the court under Federal Rules of Civil Procedure 50B, 59E, and 60B to disregard or strike the media defendant interrogatory answers as immaterial and enter judgment in plaintiff's favor on count 1. As the court agrees that relief is warranted under Rule 60B, it does not reach plaintiff's Rule 50B and 59E arguments. Okay, so this is the partial agreement. 2. Legal standard. Federal Rule of Civil Procedure 60B permits a party to seek relief from a final judgment under a limited set of circumstances. The rule permits a court to relieve a party from a final judgment for certain reasons, including 1. Mistake, inadvertence, surprise, or excusable neglect, or any other reason that justifies relief. Where it is the court's misunderstanding or misapplication of the law that is asserted in a Rule 60B1 motion, the movement must demonstrate that the court's mistake involved a plain misconstruction of the law and the erroneous application of that law to the facts. In contrast, Rule 60B6 is available only when Rule 60B1 through B5 are inapplicable and extraordinary circumstances to justify reopening. Discussion. Relying on Rule 60B1, plaintiff contends the final judgment rests on a manifest legal error because it, 1, reconsidered the same legal question decided in the February 7, 2025 order on defendant's motion to dismiss the amended complaint, and 2, permitted the jury to resolve legal classifications and standards reserved to the court. She also argues that the circumstances are extraordinary enough to warrant relief under Rule 60B6. The court addresses the arguments in turn. For the reasons below, plaintiff's contentions of manifest legal error are unpersuasive. Even still, extraordinary circumstance warrant relief under Rule 60B6 because the court assured the parties the media defendant issue would remain subject to post-verdict review, and the trial record establishes defendant was not entitled to pre-suit notice. So the judge ain't going to take full accountability for everything that Megan says, but is willing to make a concession on this one piece. Rule 60B1, plaintiff does not show manifest legal error. Law of the case doctrine. According to plaintiff, the law of the case doctrine barred the court from revisiting its February 7, 2025 determination regarding defendant's news media status. Plaintiff's reliance on the doctrine is misplaced. The law of the case doctrine posits that when a court decides upon a rule of law, that decision should continue to govern the same issues in subsequent stages in the same case. The doctrine applies only where there has been a final judgment. Yet a court's previous rulings may be reconsidered as long as the case remains within the jurisdiction of the district court. The law of the case doctrine does not apply to February 7, 2025 order. The court's resolution of the lack of pre-suit notice defense on a motion to dismiss was not a controlling legal ruling, precluding later reconsideration, particularly given defendant preserved the issue in an affirmative defense to the second amended complaint. Media defendant special interrogatories. Next, plaintiff contends that the court's media defendant special interrogatories were improper. According to defendant, the jury was authorized to decide her news media status, and plaintiff is barred by the invited error doctrine from complaining. Plaintiff asserts that the media status under Florida Statute Section 770.01 generally presents a threshold question for the court. She is correct that issues concerning public figures and whether a defendant qualifies as a media or non-media defendant are commonly resolved as matters of law outside the jury's presence. Indeed, Florida's pre-suit notice statute was intended to give putative defendants the opportunity to retract allegedly false and/or defamatory statements and potentially to avoid litigation altogether. At trial, the undersigned likewise recognized the preliminary nature of those determinations. The question is typically resolved at the inception of the case because if a party fails to give pre-suit notice, the claim goes away with leave to amend later or leave to file a new action later. Here, the issue was resolved at the motion to dismiss on record that the defendant presented and based on the pleading alone. Now, we are at the conclusion of the evidence or near the conclusion of the evidence. The record is materially different from that which I was presented at the inception of the case. And yet, the Florida Standard jury instructions contemplate circumstances where status issues may be submitted to the jury. The record here supported submission of questions regarding defendant's news media status to the jury. Assuming the court erred by submitting the issue to the jury, plaintiff invited the error. A party that invites an error cannot complain when its invitation is accepted. Because unfortunately, Megan's legal team did allow that the questions be submitted to the jury. This is why so many of us were complaining about the job that Megan's legal team did in court. Plaintiff not only requested that defendant's news media status be submitted to the jury, but also participated in drafting and approving the relevant questions and jury instructions. This is a textbook case of invited error. By proposing the exact language that the district court adopted, the party invited any purported error. So basically, it was on Megan to basically tell her legal team to stand on business. The judge had already, at the motion to dismiss stage, found that Milagro was not a media defendant. It was written in bold print. But then it was reintroduced to the jury because, of course, Milagro initially thought that that should have been judged in court. Then when they got to court, Milagro's legal team said, we want the judge to say it. And somehow Megan's legal team said, no, we're okay with sending it to the judge based on the restructuring of the question. Plaintiff first agreed to the use of media defendant special interrogatories on November 10, 2025 at a pretrial conference. Defendant's counsel proposed treating defendant's news media status as a factual issue for the jury, and the court suggested structuring the instructions as to media defendants. Rather than object to the procedure, plaintiff responded that the jury would need guidance on the applicable standards and acknowledged the issue could be okay to submit to the jury and that the proposal was fair. That's not Megan's words, but those are the words from her attorneys. Following that discussion, the parties agreed to work together to draft a jury instruction implementing the court's suggestions. On November 17, 2025, before opening statements, the court addressed plaintiff's memorandum reasserting defendant was not a media defendant. Although the court confirmed tentative agreement with plaintiff's position, the court also explained defendant would have the opportunity to present evidence and attempt to persuade the court otherwise. And when the court revisited the issue on November 21st, the parties agreed the jury instructions would remain subject to further revision depending on the evidentiary record developed at trial. Plaintiff therefore proceeded through trial aware of the issue remained open and could ultimately be submitted to the jury. On November 24th, 2025, when defendant had nearly completed her case in chief, the court again addressed the matter of defendant's media defendant status. Plaintiff, undeterred by defendant's response in support of defendant's news media status and the evidence defendant presented in her case in chief, maintained that the analysis of the issue factually is the same as what it was at the motion to dismiss. The court disagreed, explaining that at the conclusion of the evidence, the record is quite different. The court once again proposed submitting the issue to the jury through special interrogatories. Even then, plaintiff did not object to the jury deciding the issue. Instead, her counsel sought clarification regarding what evidence prompted the court's reassessment and discussed revising the instructions language. The court then directed the parties to confer regarding how to proceed. Following that conferral, it was plaintiff, not defendant, who advocated for sending the issue to the jury. Plaintiff told the court the issue could go to the jury so long as the jury received appropriate criteria to guide its determination. This is where her legal team fucked up. After the court clarified that post-verdict briefing would remain available, defendant withdrew her request and both parties agreed to proceed with the interrogatories. Plaintiff's counsel then confirmed he was satisfied proceeding in that manner because, as he put it, now that we have merged these things, I think is fine. Plaintiff's counsel also participated in finalizing the jury instructions and raised only a limited objection regarding language describing the effect of the media defendant finding. Plaintiff raised no further objections and the party submitted the final instructions without identifying additional concerns. Plaintiff also took an active role in addressing a jury question regarding how to properly evaluate the media defendant factors. Her counsel participated in drafting, revising, and approving the jury instructions and special interrogatories without making the objectives plaintiff now asserts in the motion. On this record, plaintiff invited any alleged error and thus may not challenge the interrogatories under Rule 60b-1. The litigant invited error when he not only, okay, that's not pertaining to her. In sum, plaintiff falls short of showing a manifest legal error warranting relief under Rule 60b-1. Rule 60b-6. Plaintiff shows extraordinary circumstances. Moving on, the court considers whether plaintiff has established extraordinary circumstances justifying relief. Rule 60b-6's catch-all provision authorizes the court to exercise its sound discretion when the circumstances are sufficiently extraordinary to warrant relief. The rule does not reward a party that seeks to avoid the consequences of its own free, calculated, and deliberate choices. The 11th Circuit has recognized that Rule 60b is an appropriate escape valve when counsel has acted diligently and in reliance upon statements of the trial court. The court agrees extraordinary circumstances justify Rule 60b-6 relief. Throughout the trial, the court stated post-verdict briefing on the media defendant issue would remain available, and the parties agreed to submit the issue to the court in reasonable reliance, to the jury, in reasonable reliance in part on those assurances. This is an issue depending on how it's answered by the jury that will be a subject of post-verdict briefing. Thus, the court's repeated statements regarding post-verdict briefing and plaintiff's diligence in filing her motion present an extraordinary circumstance rendering Rule 60b-6 relief appropriate. Therefore, defendant was not entitled to pre-suit notice. On the merits, plaintiff asserts that courts routinely decide whether a defendant enjoys media status and is entitled to pre-suit notice as a matter of law at the motion to dismiss and summary judgment stages of a case. Plaintiff acknowledges that the court could arguably submit narrow factual questions about predicate facts to the jury, but insists the ultimate legal determination whether defendant is a media defendant for Florida Statute 770-01 purposes remains for the court to decide as a matter of law. The court first decided on the question based on the amended complaint's allegations. The court now decides it based on the trial record. Again, under Florida law, a plaintiff must provide written pre-suit notice before bringing any civil action for defamation based on a publication or broadcast by a media defendant in a newspaper, periodical, or other medium, Florida Statute 770-01. A publication qualifies as an other medium if it is operated to further the free dissemination of information or disinterested and neutral commentary or editorializing as to matters of public interest. Blogs may fall within the statute when they serve as an alternate medium of news and public comment. Defendant's broadcasts qualify as an other medium because her shows are operated to provide live commentary in the nature of providing information, news, and commentary in the field of entertainment. As defendant testified, she selects topics by analyzing social media algorithms, reviewing viewer-submitted content, and consulting reports, articles, and court documents to determine matters of interest to her audience. Because her broadcasts are live, defendant also reviews and responds to comments from viewers in real time to give commentary and to incorporate the viewers' comments into the show. To be sure, although defendant is a broadcaster, not every statement she makes falls within the purview of Section 770-01. Plaintiff identified 3 defamatory statements. 1. Defendant's statement that plaintiff was a non-credible witness. 2. Defendant's statement that she could go down the list of all the different shit that was not true. And 3, defendant's question, was Megan Thee Stallion caught trying to deceive the courts again? The first was a December 21st, 2022 post on X. The second occurred during January 5th, 2023 podcast episode where defendant was being interviewed about the Peterson trial. The third was August 7th, 2024 from defendant's account accompanied by screenshots of legal documents from another case. Plaintiff argues that defendant was not entitled to pre-suit notice because she engaged in financially motivated advocacy and disseminated information at the Petersons' discretion. Plaintiff relies on the jury's findings that defendant did not provide disinterested and neutral commentary or impartially disseminate information and acted extremely and outrageously by coordinating with Daystar Peterson and others. That defendant did not provide disinterested and neutral commentary or impartially disseminate information does not automatically destroy her media status. The existence of a particular agenda does not rob the speaker of the protections afforded by the pre-suit notice statute. And media defendants are not limited to those who impartially disseminate information or issue unsolicited, disinterested, and neutral commentary as to matters of the public interest. The term also applies to those who editorialize as to matters of public interest without being commissioned to do so by their clients. So, you can be biased, you can be partial, but you can't do it at the discretion of your clients paying you to do so. DJ that don't spin, your time is coming, homie. The key question, therefore, is whether defendant was commissioned by the Petersons to publish or broadcast those 3 defamatory statements. In this regard, plaintiff's citation to Ortega Trujillo is constructive. In Ortega Trujillo, a public relations firm disseminated a defamatory press release on behalf of its client and sought the protection of Section 770.01. The court disagreed, explaining that as a registered agent for its client, the firm was in the business of public relations and lobbying and did not issue unsolicited, disinterested, and neutral commentary as to matters of public interest or editorialize as to matters of public interest without being commissioned to do so by his clients. The evidence shows defendant was commissioned by the Peterson family to make the 3 defamatory statements. This is the judge's order stating it. When first approached by Daystar Peterson on September 17, 2020, defendant stated, "If you gave me any exclusive, it would change my life." And afterward maintained a close relationship with the Petersons. The first defamatory statement, defendant's December 21st, 2022 post calling plaintiff a non-credible witness, was made the same day Daystar texted defendant, "It's Tory, hit me." By that date, defendant had received payments from his daddy, obtained information from the Peterson team before other media outlets, and sent materials to assist Daystar's criminal defense. What media outlets you know do that? The second defamatory statement, defendant's January 5th, 2023 appearance on the DJ That Don't Spins podcast, was also made the same day his daddy texted defendant, "Hi Mila, call me ASAP." The third defamatory statement, defendant's August 7th, 2024 post asking whether plaintiff was caught trying to deceive the courts again, followed the June 10th, 2023 Zoom meeting where participants, including defendant, discussed using a third-party strategy because statements damaging to plaintiff needed to come from someone other than Tory, whose own statements could be held against him. Defendant confirmed her understanding of that role, inquiring about the content the Petersons were looking for. And as late as February 2024, Sunstar continued to direct defendant to speak on matters he could not address himself. The third statement was consistent with that ongoing arrangement. In sum, because the trial record shows that defendant was commissioned by the Petersons to publish or broadcast the 3 defamatory statements, the court finds as a matter of law that defendant was not entitled to pre-suit notice. Conclusion. Accordingly, it is ordered and adjudged that plaintiff Megan Pete's motion to reinstate jury verdict as to defamation claim and to amend final judgment or renewed motion for judgment as a matter of law is granted in part. The jury's verdict as to count 1 on plaintiff's second amended complaint is reinstated. An amended final judgment will issue by separate order. I have that as well. Amended final judgment pursuant to the court's May 29, 2026 ECF granting in part plaintiff Megan Pete's motion to reinstate jury verdict as to defamation claim and to amend final judgment or renewed motion for judgment as a matter of law. It is ordered and adjudged as follows. Judgment is entered in favor of plaintiff Megan Pete on counts 1, 2, and 3 of her second amended complaint and against defendant Milagro Elizabeth Cooper. Plaintiff shall recover from defendant a total of $75,000 in damages, which was the lowest possible total that the jury agreed to. Requests for costs and fees shall not be submitted until after any post-trial motions are decided or an appeal is concluded, whichever occurs later. So understand the $75,000 is just for defamation damages, defamation and the 3 counts, right? However, Megan Thee Stallion can still request for costs, legal fees, etc., but not until any post-trial motions are decided. I believe Milagro did file an appeal. So after all of that is concluded, they'll decide what she owes in costs, legal fees, etc. So that's not off the table, but it will come at a later time. Okay? So although Megan Thee Stallion was ultimately shafted by her legal team for a certain level of incompetence out there in Florida, she was also shafted by the jury because they sought to give her the lowest possible amount because based on the filing, it had to be in excess of $75,000. They gave her exactly $75,000 to the dollars and cents. That's the highest that it could possibly go based on the jury. But the judge did agree that Milagro is not a media defendant, so that new media title is now not seen in court for her. She bragged about it. She cheered about it. She chanted about it. Nope. They've added that original $75,000 judgment, or they had changed it to $59,000. It's back to $75,000. And again, once all of this is concluded, Megan can then pursue legal fees and other costs at a later time. All right? Let me know what y'all think of all this down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. I'll catch y'all on the next one. Y'all be good out there, man. Peace.
Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'm never politicking, the drama be piling on. Father and great son acknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5 sit bank accounts, every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that I read for filth. The sympathy calls, consulting for the stacks I built. I had to evolve.